Well, Jonathan didn't need to run out of time. He could have talked a lot longer as far as I'm concerned. He's got so much to say, and I hope he gets more time in the question and answer period. With respect, I didn't deal with dozens of habeas cases. I dealt with about 4. It just seemed like dozens. The habeas. Well, first of all, I want to give a plug for this little book, a few of which are up here on the table. This is a joint effort of the Human Rights First and the Constitution Project called Habeas Works. It is a defense of habeas decisions by the courts, written and signed by former judges. So if you think it's somewhat biased, I suppose it is, but it's also, I believe, an excellent kind of overview of the whole habeas process and how it is developed in the district courts. The truth is that the district judges in my court have had to kind of go back to first principles and relearn what habeas is all about. Habeas before Guantanamo was a writ that we had fallen into, essentially into disuse, except in criminal cases, as sort of a second bite of the apple after an appellate decision. You go back for habeas corpus in state courts, and the District of Columbia is not a state court. We just didn't see that much habeas. The Supreme Court had to relearn habeas really in the Boumediene case, because they've been deciding habeas cases except for the 2 that preceded it, Hamdi and Rasul, is it? They've been dealing with habeas for the last 50 years, mostly in criminal cases. And what the Supreme Court did in Boumediene is to rediscover what is known as constitutional habeas. Congress tried to take all habeas jurisdiction away from the district courts. The Supreme Court said you can't do that if it's constitutional habeas. The great writ, the fundamental writ of habeas corpus guaranteed by the Constitution, still exists. Congress can't take it away except under very specific wartime or revolutionary conditions. But that left it to the district judges like me to work out case by case what habeas meant in these Guantanamo cases. Now, the authority that the government has to hold prisoners in Guantanamo comes from something called the Authorization for Use of Military Force, the AUMF. And that says if a detainee is part of Al-Qaeda or a similar organization, or gave material support to Al-Qaeda or a similar organization during the time of hostilities, you can hold them. What the Supreme Court said, and I'm going to jump to the bottom line here, which Mason wants us all to address, is the subject of indefinite detention. What the Supreme Court essentially said was, yes, you can detain somebody if he meets these criteria under the AUMF for the duration of the emergency, which everybody thinks must be understood to be indefinite. No judge is going to decide when the emergency is over, I don't think. Judges may decide that somebody has to, that sooner or later somebody has to decide that indefinite detention is improper, but for the time being, we're looking at indefinite detention of people who don't pass, who pass this AUMF test that they're part of Al-Qaeda. Now, deciding who is part of Al-Qaeda is still a rocky path for district judges. In my case, and I suppose the reason I'm here is because I decided a case called Salahi. Salahi is detained at Guantanamo. I ordered him released under a writ of habeas corpus. I was reversed by the Court of Appeals. The facts of the Salahi case are complicated, and I won't dwell on them except to tell you that this is a guy who swore an oath of fidelity to Al-Qaeda in 1991 or 92. In 1991 or 92, Al-Qaeda was our friend. It was the Mujahideen. They were fighting the Russians. So there was nothing wrong with that oath in 1991. But the question is he stuck with that oath forever or not? He went on to leave Afghanistan. He went to college in Germany, and then he did a couple of pretty wiggy things. He apparently hosted three fellow countrymen at his house in Frankfurt one night, and one of them later turned out to be one of the architects of the 9/11 bombing, and two of them turned out to be pilots of the planes that crashed in 9/11. Also, he wound up in Montreal or Toronto, I've forgotten, someplace in Canada, pretty closely connected to people who later turned out to be a cell of Al-Qaeda who tried to do something with the Los Angeles airport at the turn of the century. So there was a lot of interest in Salahi, and Salahi also had the misfortune to have a brother-in-law who was a close advisor of Osama bin Laden. So he had a familial contact with Al-Qaeda. I found, after considering all the evidence, which, by the way, comes to a judge in a number of different formats, it's intelligence clips, it's hearsay, and it's the testimony of the detainee himself by closed-circuit television from Guantanamo. I found on the basis of all the evidence in the case that although this guy was a sympathizer and probably a fellow traveler, he was not part of Al-Qaeda. Well, circuit court, in an opinion written rather gently, I must say, by my good friend David Tatel, who maybe didn't want to be too nasty to me, reversed me because I had failed to anticipate what the Court of Appeals would do in three cases after my decision was rendered. In one of them, Judge Randolph, who yields to nobody in the stuff that he reads and imports into his opinions, in one of them, Judge Randolph wrote that one of my colleagues had failed to apply what he called a conditional probability analysis to her analysis of the facts, and had engaged in the fallacy of the possible proof. These are not legal concepts known to anybody but Judge Randolph, but they're now the law. They're now the law of the D.C. Circuit, and I and some of my colleagues, by failing to anticipate them, got reversed. And so what Professor Havett said is absolutely correct. What's really happening now is that the district judges are just doing the best they can to decide these cases and then send them to the Court of Appeals, who will redecide them based on what they think of the facts. That's the real world, and that's the way these cases are going to unfold. Now, is that altogether bad? No, it's not altogether bad. There are critics of this process, Ben Wittes being one of the most one of the best known of them. They're critics of these processes who say we shouldn't leave this to judges. Congress should decide what the standards are. But I say the common law was made by judges, and it worked itself out in an ugly way, just the way this is doing. But now, of course, district judges have to not only get the right answer, but show their work like you had to do when you turned in a geometry problem. You had to show your work before the Court of Appeals will agree with you. But the short answer to Mason's question, and she's told me I'm out of time, is will this habeas process be able to do anything about indefinite detention? Answer, no.
Well, I think we would all like to give you a few minutes to explain that. Would you like a minute?
Well, it is going to be, now that, this is not to say that one or more brave judges will not try to do it, will not do as my colleague Judge Urbina did in the case of the Uyghurs and say enough is enough, you can't keep people indefinitely. There is a point beyond which we don't know where it is, but I say it's in this case, you got to let this guy go. But the law, as announced by the Supreme Court in the Hamdi case, is quite different. The Supreme Court said you can keep people as long as the emergency exists. Now, I said in Salahi that the habeas court can't keep somebody forever on mere suspicion. But if the facts adduced by the government on a habeas petition show that he was properly held in the first place, then in my view of what the current law is, there's no way a district judge can overcome that and order the release of a habeas detainee. Now, my colleague Ellen Huvel found differently in a case she was working on, and she did order the release of somebody, but she ordered the release, I think, on the basis that there wasn't enough to hold the person in the first place. So I think there was no appeal from Judge Huvel's finding, and this person was let go. But if it is appealed, I don't, and if it gets to Judge Randolph, I don't have much hope for that kind of decision.
Thank you, Judge. Mr. Engel?